in those feedback forms, saying in the feedback form, I'm not so sure how to select correct information, and how much information I need to include. A lot of people, and that is not just, it's a lot of people have that problem. So if you can keep in your head, why am I writing this? It will keep you focused. It'll keep the mind focused on what your initial aim is when doing this. And it'll get rid of the nice to know and get down to the need to know. The nice to know can be put into lectures or but that can be put at the end so people can just read later. But get to the...
Well, good afternoon, all our members and non-members that have joined us today. I want to kick off early. We've got 1 hour to discuss a multitude of questions around POPIA and related issues. I want to say there are some ground or house rules. If you are not speaking, please put your mics off so we don't get any disturbances. And if there are questions that you like posed to the panel, please put them in writing on the side, and then we can take it from there. But let me just talk through the proceedings of the meeting. So thanks for joining. My name is David Dickens. I'm the CEO here at the DMA, and it's awesome to have you. I see the numbers are just rolling in, which is great. It stops me from answering each individual question that comes on my telephone. It's great to have you as a group. So, the DMA is always putting forward ways of connecting, and we were very happy to connect with the Credit Bureau Association as well today. They are assisting us, and we're also getting some expert legal advice from the Weavand firm. By way of introduction, I would like to introduce Alison McGrath. She is the chairperson of the Credit Bureau Association, and the other panelist is Stefan Oberholzer. He's the CEO of Weavand Online and also a legal advisor around POPIA. So we're going to kick off with a list of the frequently asked questions. We've taken the 9 most asked questions and we'll pitch it between myself, Stefan, and Alison. We'll take some further questions that come through from the lobby and people online. So somebody can hear me. If somebody can't hear me, just put your hand up. I'll speak louder. So I did the good afternoon, everybody. I did my greeting. Those that are from government as well, all protocols observed. Thank you for joining us. Thank you for the CBA Association for joining us as well and giving the inputs. And I must say, it's 49 days to the 1st of July. I think it's on everybody's mind, and it's definitely keeps me up at night. As we were discussing earlier, Stefan, he said it right. POPIA has been a humbling experience. And it's something I keep very close to me. If you see this POPIA guide, one doesn't want to speak out of turn, but one wants to understand the practical approaches to it. So let me kick off. The first question that I've been asked is from the call center agencies and associations. They ask, can outbound call centers do person-to-person calls? And can cold prospects be called from a list of numbers from that call center? So there's a question. Call centers, we're talking about person-to-person specifically. We won't go into digital dialers because we understand what POPIA says about that. We're talking person-to-person. I think that's a question Stefan's been pitched time and time again. And I'd ask Stefan to take that one for us, please. Can you offer us some advice on that?
Certainly, thank you, David. Just, if you guys aren't able to hear clearly, just give me a shout. Thanks very much, David. Thank you for making us part of this. As always, it's a privilege to join these forums and these discussions. We do appreciate it. I think at the outset, before we sort of dive into some of these questions, I just want to, I think make clear and qualify that I think certain of these questions, we're going to obviously answer them as best we can. I am going to be always the first one to tell you guys that, I don't necessarily know the answer to a particular question, or, there's perhaps multiple interpretations of it. I think that's very important to just at the outset make clear. And ultimately, we are also digesting these types of topics on an ongoing basis. We are required to interpret this legislation, on an ongoing basis as advisors and in this POPI space. I think a lot of these sort of questions are going to be afforded clarity as time goes on as well. So we're gonna give it a shot, and ultimately where we are unable to sort of provide you necessarily, I think there's a difference between the answers that we provide and the answers that all of you necessarily might want to hear. And we stick, like David said, very closely to the Act, and we got to revert back to the Act. We got to interpret the legislation in alignment with the what we believe the intention and the objectives of the legislature were and are. So I just wanted to sort of start at the outset like that, and I'm sure Alison is going to support that as well. So with that said, let's dive in. I think there's a couple of, with this first question, David, there's probably varying interpretations of it. I've been posed this question a number of times in different ways. I think it all depends on how, a call center or a lead generator, a responsible party that makes use of a call center interprets certain of these terms and definitions. Like, for instance, what is an electronic communication? I've got my view on it, and I think one must be very conservative in respect of your sort of interpretation of some of these definitions. So I think the crux here is that, first of all, person-to-person call, my interpretation of that is, a direct, a human being contacting another human being on an outbound basis, whether it be in an insurance call center or in a lead gen call center, whatever the case might be. And the question is whether that is allowed. Can you do that in respect of a cold prospect, so to speak, who is not a customer, or potentially, I suppose, part of an opt-in existing database that particular call center commands. So I think the first thing is, one needs to go back down to what is the sort of what is the intention of, because I think, in my view, one needs to go and break down and unpack the definition of an electronic communication. And let me maybe start out by saying, yes, that is allowed, but there are certain qualifications that one needs to go and take into account. Would that engagement constitute, in my view, direct marketing, is perhaps the first question. And then, depending on the answer to that, is it direct marketing by means of unsolicited electronic communications? And I think the interpretation needs to be whether that call and that engagement is an electronic communication, which is done on that particular basis. So if you're going to have a look at the definition of what electronic communication is in terms of the Act, I've got the Act open here in front of me. It means any text, voice, sound, or image message which is sent over an electronic communications network, which is stored in the network or in the recipient's terminal equipment until it is collected by the recipient. There's reasons why lawyers draft long opinions on these types of issues as well. So I'm not going to sort of take a position, one way or the other. Ultimately, my view is that we need to unpack what that means for your business, for your scenario, in as far as what an electronic communication is. I don't know, and there are people that differ with me on this. I don't know that you can necessarily exclude a phone call, from the scope of the definition of electronic communication. We also need to go and potentially look at the Electronic Communications and Transactions Act as well. Not potentially, I think definitely. So I think the answer there is, yes, you are allowed to do that, but we need to go and qualify it. POPI is not wanting to prohibit these activities, in my opinion. I don't think that's the intention of the regulator or the legislature. I think the intention is to regulate those activities and, in a way, encourage us to do business differently. It all boils down to what is the objective of the Act, and I think transparency, openness in any sort of engagement is ultimately key. So whoever asked that question, I'm not sure that I actually answered it directly. I'm happy to sort of have an engagement afterwards, but we'll have to interpret it, based on your particular scenario.
Thank you, Stefan. I think that was quite well answered. So I'm going to go quickly on to the next question, and it's quite a long one, with a little bit of a double barrel, but it's a good one because I get this, and it needs to be answered. So if a lead generation company receives a reply on a marketing message, and if this message is sent by an insurer, and that and an example here is if Hollard sent a message, and this message was sent on behalf of a lead generation company, and if a prospect answers yes, call me, who gets the consent? Is the consent Hollard's, or is the consent the lead generation company's consent? And can that lead generation company use that consent to sell something else? So that's the gist of the question. And I'll bowl that to you, Stefan, again, if you can let us know the answer to it. I'll give a practical example as well later.
Okay. So it's quite a loaded question, but let's go. So ultimately, I think what it boils down to in simple terms, and I really like to sort of be pragmatic about these things, is that I don't think you can go to heaven on another guy's ticket. And I think that is sort of what needs to guide our sort of, thinking and how we unpack and debate this particular scenario. The first thing, obviously, is to determine, who you are, your legal position. Are you a responsible party, an operator vis-a-vis that data subject? I think that in sort of, in practice and the way things happen on a day-to-day basis, is also, we are wanting to, and we are constantly having to apply this legislation that is, until it is amended or supplemented by regulation and additional guidelines. It's still very early days. So we kind of still, I think, in my view, need to see the legislation and business and how things practically work at a grassroots level kind of, dovetail off of one another. And that's still going to happen. But ultimately, firstly, you got to establish who you are. And I don't think that it was the intention of the legislature to sort of, put lead generators out of business in this way. I think ultimately, whoever it is that is the responsible party in relation to that personal information pertaining to that data subject who's being engaged or contacted needs to take particular steps to comply with, the notice requirements in terms of the Act. I think what we also need to do is be very careful between, I think there's a difference between opt-in and consent. So opt-in and consent, in my view, often get sort of termed and used interchangeably as one and the same thing. And I don't think that that's necessarily the case. Opting in is not necessarily an explicit grounds for, or justification for lawful processing. So I think that there's a couple of things that the supply chain or this value chain needs to take into account. Is first of all, where did the information come from? Where did this contact come from? How was it generated? Is it a customer within your database? Is it an opt-in contact that is actually opted into receiving? You also have to be quite specific, I think, with that opt-in. You can't and that I think goes back to what is the intention of the legislature, is to say, listen, you can't process personal information for purpose X and be opportunistic and process it then later for purpose Y. You've got to be real. You've got to go back to being open, honest, and transparent. I don't think you can necessarily rely on someone else's consent if that consent was needed in the first place. And ultimately, I think you need to establish there might be more than one dynamic involved there. You might start off as the responsible party, but evolve into the operator role at a later stage. And then, the obligations then differ. So I think that's the way one needs to approach that. And again, I say I think one needs to be cautious. Rather be overcautious and try and that's my opinion. Try and not assume things.
Thank you, Stefan. I was asked similarly that question at one of my talks I had, I think it was 2 weeks ago. And if Hollard was the party that employed you to do the job for them, and they've paid you and they have asked you to develop an intimate list on their behalf, they then have asked for it and had a specific purpose and intention. You were just the handler and they actually own the list. So I think that would in short go to Hollard. And then the other side of it, when you look at a HIPPO is very generic. When they ask for your consent, they clearly state that we are going to send you quotations on insurance that could meet your request or your need. And they would be from multiple vendors. And if you say, yes, I'm in the market, obviously then you're getting a multi-vendor. You'll get a couple of views of different types of insurance policies. So it's two parties. The consumer must be wise in understanding what they're opting in for. And of course, business needs to have, and Stefan talks about it all the time, make sure your contractual obligations stipulate between the data owner, processor, handler, who owns what and for what purpose. And then I think everybody will be on the right side of how they behave with that data. But thanks, Stefan. Let's move on to the next one. It says here, after July the 1st, are we going to still be able to update our database with information from credit bureaus, either for clients, customer base, or for our lead gens? And I think that is clearly one in your court, Alison. Come 1st July.
Afternoon, everyone. Thanks, David. So just like Stefan said, a few notes of warning. I'm absolutely not a POPIA expert. I run the Credit Bureau Association, and we have done a lot of work to try and get ready for POPIA as an association. So I can give some of my learnings from what I've gathered from the experts. I'm by no means an expert, so that's the number one kind of qualification. So in this particular question, it's always a tricky one. It's forever been a tricky one. It's going to remain a tricky one. So let's first just remember, I think, that POPIA is principle-based legislation, not rule-based. So credit bureaus are governed primarily, hopefully, by the National Credit Act. This is a rule-based legislation. It says you shall or you shall not. You must or you must not. POPIA doesn't do that. It says these are the principles you must apply. So whatever question we come to, look to see how you are applying the principles and try to come up with reasonable arguments as to how you have applied those principles, and that goes a long way to satisfying the information regulator should they knock on your door. You need to have documentation to show that you have applied your mind and that this is what it means. And so that's the kind of work that we've done as an association. So going to this particular question, it's marketing. Effectively, call it pre-vetting, call it whatever you like. It's the same thing. So various credit bureaus have done different things. They aren't all aligned in what they do. Credit providers will tell you one thing. Their marketing department will tell you a different thing to the risk department. So there's very little consensus as to what you are allowed to do throughout the industry. So now it comes to POPIA. So you're already hitting something that's a complete quagmire. What do you do when you now hit the POPIA regulator? So our view as credit bureaus is that the NCA is pretty clear for us in terms of pre-vetting. The NCA says that credit providers are obliged to check that the consumers that they are marketing or that they are offering a product to, and that's a credit product, must be checked to see that they can afford that product. So in our view, that's pre-vetting. If you're looking strictly at the Act, we argue that that's absolutely down the line in terms of the NCA. What becomes very much less clear is what happens when it's not a credit product, not for credit purposes. So if it's for insurance purposes or other purposes. So in terms of the Act, someone is only allowed access to the records of a credit bureau for a prescribed purpose. And for many parties, you have to have consent for a prescribed purpose. So without sort of saying a bureau may or may not, in terms of insurance, we would generally ask for the consent of the consumer to be obtained before you market for an insurer. So I can't say that that applies to every bureau, but that's the approach. And what we did was we held a seminar with some of the industry experts, and we put our views to them. And I think what they kept on telling us, document it. Go through the thought process that you have been through, put it down, write it down, and say why. And say why, in your instance, the consumer is protected. So if you look at the ambit or the beginning purpose of the NCA, read the purpose, is very interesting. It gives you quite a wide scope for trying to argue that there is definitely purpose to allow persons who would not otherwise have access to products to be given access to products. That's in the NCA. It's in the front of the NCA. So that's the kind of logic that you need to go through when applying these kinds of questions. I'm not answering the question directly. I'm telling you the thought process you need to go through for yourselves.
Yeah.
David, do you mind if I just supplement Alison there? I just wanted to sort of, from our perspective. Yeah, sorry.
You can definitely come in, Stefan, but what Alison was saying was something that I picked up in, well, my Bible here of the Info Regulators POPIA Act. And it's the preamble of the Act that goes in and says, very similar as to what you had said, and bearing in mind that consonant with the constitutional values of democracy and openness and the need for economic and social progress within the framework of information society requires the removal of unnecessary impediments to the free flow of information, including personal information. Very, very much what you were saying in terms of it's not rules-based, it's principles-based. So if the principle is to act within trying to maintain an open market and give every South African access to this market, then yes, keep the notes on it and say how they are protected and why you're not infringing on their rights or withholding them. But thanks for that. Yes, Stefan, let's hear.
No, I actually was going to say what you said, perhaps just in a different way. I think, what I really liked about what Alison said there, and that's kind of been my guide. There's no textbook to this either. And I think what we must also just do, and I encourage, responsible parties out there to do that, is, the regulator and the members of the regulator, the people who work in the office are people. We're all human beings, so we are all interpreting this legislation. So, we kind of have to be a little bit also gracious and understand that, there's going to be a learning experience, I think, for all of us, and we must, maintain, I think, that general attitude towards it. But what is your legitimate purpose as a business? And I think if we can cut through everything, that's what this act comes down to, is to regulate responsible parties so that they do with our personal information what is legitimately necessary in protection of our legitimate interests as data subjects, and in pursuit of your legitimate interests as a responsible party, your business. So, I just wanted to sort of leave it at that, because I think that's really, really important to kind of keep in the back of our minds.
Thank you. That was an important end to that question. I'm going to move on. Number 4, I think everybody, this is on everybody's lips. Should we not get prior authorization before the 1st of July because of Section 58(2)? But before I get here, I saw a question pop up saying, what is going on with the regulator's website? How can we already put our CIOs on? And what I want to say to answer to the question is, yes, the site has, as you saw, some gremlins that crept in and it is not working. But I see they've subsequently put another note on saying that, look, guys, it's not the be-all and end-all that you can't register today. You will have an opportunity to still register your CIO. So don't stress. But obviously, we as associations that are compliance officers are stressing. And again, I'd say to those that are on here, wait till the end. I've got an interesting note where the associations, the CPB and the DMA are having a roundtable. And I'll give you some info on that. We're doing it very quickly so we can try and assist the regulator with what is actually happening with those gremlins and see how we can assist. But okay, let's go back to the question. After the 1st of July, are we going to still be able to update our database? Oh, sorry, no. I've gone right back. Should we get prior consent before the 1st of July because of Section 58(2)? And will we have to cease to operate? Hey, who wants to take that one? They love you or they hate you.
I think let's tag team it.
Start on it. So I think the first thing you need to look is at the type of information that you're processing, because it's certain types of information that require a prior authorization. So if you're a credit bureau, you fall bang in the middle of it because you process information for the purpose of credit reporting. I would say that a lot of you are rather going to be in the category of 57(1)A, which is processing unique identifiers of data subjects, meaning such as an ID number or something like that. And it's for a purpose other than which the identifier was specifically intended at collection, and with the aim of linking the information together with the information processed by other responsible parties. So if you don't fall into that category and you don't fall into the category of credit reporting, criminal behavior, or the transfer of special information, then those are the categories that require prior authorization. For credit bureaus, this is critical. If we do not, and one of the things that you don't have to do if you have a code of conduct, you don't have to apply for prior authorization. So we as an industry credit bureau association, we have done a code of conduct, which I'm sure you all saw on the website. And provided that our code is issued in time, we won't have to apply for prior authorization. For us, this is touch and go. Because the regulator issued the guidelines for code of conduct very, very late. And moreover, we met with them on the day that they actually issued their guidelines, and they asked us please to wait even longer while they issued their complaints guideline as well. So from the date that you actually submitted your code, we had 13 weeks in terms by which the regulator actually has to approve or not approve our code. 13 weeks is going to take us to the 15th of June. So we're like very close to the deadline. So we're all quite nervous because it will mean if we do not get prior authorization that the credit industry comes to a halt on the 1st of July, unless an angel comes to our rescue. So it's a very, when the information regulator put out their guideline on prior authorization, it's in a guideline. There are going to be legal people who argue that you cannot legislate by way of a guideline, which is a correct interpretation. Nonetheless, it's there. And the regulator is saying that if you do not have prior authorization and you require it, you won't be able to continue operating from the 1st of July. That's our interpretation of that section. So check the provisions of section 57 to see if you fall into that category of people that requires prior authorization. And if so, then you need to look at applying. But of course, the regulator has the right to come and examine, investigate, and then that pushes the timeline out a little. Stefan, over to you.
I think, yeah, I hear you on that definitely, Alison, and I think that in all honesty, you know, there's various views on this, and I am following with our clients, and the position that we're taking is sooner rather than later. Obviously, if it is required, you know, and to rather be rather have it. Well, I also say that on a qualified basis because, you know, I don't think the intention of the regulator is to receive, you know, spam, you know, applications for prior authorization in case you need it at some point in future. So I think they want you to be relatively specific about, you know, the instance that you are applying for prior authorization for. And I think the guideline, I won't sort of hijack the screen now, but, you know, we can share with all of you guys after today, just in case you haven't seen it yet. There's a guideline on, you know, unpacking this that the regulators published, and it's actually quite useful. It sets out 5, actually only really 4 instances and activities and categories of personal information in respect of which you have to apply or notify the regulator of your processing activities and effectively apply for prior authorization for. And, you know, I agree with you, Alison, I think the credit bureaus are smack bang in the middle there. But in reality, you know, most businesses do credit reporting as well, albeit perhaps just for internal purposes, you know, and I think that whether it was the intention of the regulator to sort of capture everyone there, I don't know. I'm not certain. I don't believe so, but I'm saying that without wanting to sort of put any words in their mouth. I think the way we should look at it is go and interpret the guideline alongside section 57 and 58, and ultimately, you know, apply for it. It's not supposed to be difficult to do. It's something you need to, the hard part there is not compiling the application necessarily. The hard part is to identify whether it's necessary for you to do it or not. And go and unpack those instances very carefully, break them down. It's where you process unique identifiers, but there's certain hurdles you have to jump over, number one, and you can go and have a look at what the definitions of unique identifiers are. But number one is where you process unique identifiers, and it's for a purpose other than the purpose for why you initially, intended it at collection. That's a pretty, big step to jump over, number one. And number two, you've got to read that with the sort of condition relating to further processing limitation. So, is the purpose that you're processing it for today so far removed from the purpose for why you initially collected it? And I'm paraphrasing and oversimplifying it a little bit, but, ask yourself that question. That's the first step. The second one is that you need to also then link it with, or have the intention of linking it with, personal information that's processed by other responsible parties. So there's a very sort of, in my view, sophisticated process that needs to take place in order for you to qualify there, and that's what I think, the sort of scenario is there. The second instance is where you are processing personal information pertaining to unlawful or objectionable conduct of people, their criminal behavior, etc. But there's a key qualification where you're doing it on behalf of third parties. So go and have a look at that. The third one is credit reporting. The fourth one is special personal information and personal information of children, where you're transferring it across the borders of South Africa to countries that don't have adequate data protection laws and regulations in place. And then the last one is where we're going to see things develop. And that's why the key thing here, guys, is we have to keep an eye on what the regulator views as processing activities that could potentially influence and pose a risk to the legitimate interests of data subjects from time to time. So that list is going to grow, and we need to keep it in mind, and then we need to go, and when those sort of instances are identified, we need to go back and interpret it to your business and your processes. So my view, and I would encourage you, if you believe that it's necessary, if you're uncertain, you're welcome to call us. We can help you debate it and unpack it. But if you believe it's necessary, sooner rather than later. Also, don't inundate the regulator, or try not to, because they are already sort of under so much pressure. And I just want to say, David, that if you've ever developed a software application or a system before, it never goes live when you say it would, number one. And number two, just things break, guys. So, watch the space. All right.
Just for the speakers, I see a guest is saying, can we provide tighter answers to the questions?
So I don't know if you were there in the beginning who have asked that question. I think it comes back to the whole thing. We're used to rules. We're used to legislation that says you can and you cannot. If you do this and you shouldn't, this is the repercussions. Whereas POPIA is something completely different. It's principle-based, which means you have to think, which means you have to take the principles and apply them to each particular circumstance in your business. It requires a lot of thought. Yeah.
Oh, okay. Well, that is exactly what we had discussed in the beginning, that, to say that there's one answer that blankets each institution is going to be varying. One has to apply thought, keep records, as you had said, Alison, and have a reasonable and a rational way in which you are actually putting into practice how you're going to work with data. Well, let's move on, because we're getting questions, and I see we've already got a question that's been asked. I think it is let me just check. By Gregory Makama. It's one we're going to ask right now. Who should be appointed as an information officer, and can that role be outsourced? So again, I think that's more legal and in line with Weven.
Okay. So, I mean, we often get asked this, in practice, and this question becomes very practical when you're dealing with groups of companies specifically, because I think the very first thing that everyone needs to appreciate and understand is that There's other legislation applicable here as well, specifically the Promotion of Access to Information Act, POPIA, that needs to be read with POPI. And in actual fact, and this is my interpretation of it as well, but in actual fact, every responsible party, whether it be a public or a private body, as defined in terms of the Act, you actually already has an information officer by default. It's the head of, and I don't say by default, but it actually is what it is it's the head of that private body, whether it be the CEO, the managing director, you are the information officer. So yes, there is that entitlement to be able to delegate that authority to somebody else. And I think it's debatable. Sorry, David.
Stephen, and I'm seeing we need some practical idea examples. So example, I'm heading up the DMA.
You are the DMA's
by
information
default
officer.
The CIO.
Yes.
I would then have to, in my data policies and contractually, then remove the function from me to an actual CIO. I can remove that function to a party or person in my institution that is qualified, maybe more knowledgeable, and who's employed just for that task. And therefore that responsibility would rest with that particular person. But currently, if I have not, and we don't practically have that person in the company and legally employed, I am by default the CIO. So I better brush up on everything in terms of how data moves and where data is stored and
how not to go to prison.
10 years, and I don't have 10 million to pay the regulator, but yeah, that was just by practical application I'm talking about. So please go on, because I think the second part was, can you outsource it?
Yeah, I think what I'll do, David, if it's okay with you, and also just in the interest of time, is I'll answer question 5 and 6 sort of, in tandem here. But ultimately, the head of the private body is the information officer. And obviously, if you are the CEO of a company, or, you are at that executive level, you 10 to 1 don't have the capacity necessarily to do what's necessary in order to execute all of these responsibilities. You can go and have a look at Regulation 4 and Section 55. So what the Act does is it entitles you to, and I'm not going to use the word outsource here, because I don't think you can outsource certain functions, but you can't outsource the liability. And I think that was the intention of the legislature here, was to say, listen, we understand you CEOs are busy, give the work to somebody else to do, but you have to remain accountable for it, number one. And number two, you can step in at any time and should step in at any time to sort of remove that delegation. Okay, so ultimately what information officers do in the default position instance is they appoint deputy information officers to basically be their hands and feet and to do the work. There needs to be a specific appointment there. I also want to make it quite clear that I think you must be very sort of careful in respect of these appointments, because you have to provide these people with resources. You have to also, you don't have to have, in my opinion, a very specific qualification. The regulator's guidelines dictate that those people should at least be at an executive or a management type level. My qualification, practically speaking, to all of our clients is that you've got to delegate that responsibility to somebody who's got the access to the business, who understands the business, and who's got the gravitas and authority to be able to make these things happen and enforce these responsibilities. So that is, my position in terms of who the information officer is and how you actually practically execute the responsibilities. Then, obviously with small companies, I think that was the sort of tail end to that question. We've got to be pragmatic about this as well. If you are a sole prop, or if you are a smaller business with a board of, 2, ultimately, you've got to recognize there's a default information officer there, and you've got to sort of take responsibility for your business's compliance here. You as the responsible party, as the information officer on behalf of this responsible party. And with regards to the registration, we're waiting for the portal. And we are also currently what is available to us is to do manual submissions. I think that's what I was saying earlier is, let's just be a little bit gracious. We develop a lot of software applications and, it never goes according to plan. So let's wait, let's give the regulator an opportunity to make the system live. And then, that's how the registration process is intended to take place. If push comes to shove, the manual submissions are always the way to go, but let's just be logical about it as well. We are in COVID times at the moment, so let's not send all of our couriers to the regulator's office. I think is what my view is.
I think that's what's going to happen. Thank you, Stefan. We say sooner than later, get your application in, and I think no one wants to miss that deadline. And then I see here, who can we arrange a consultation with? So if I've put online info@dmasa.org for further questions, and we will assist and we will give you answers. And if you want to get in contact with a consultant, we'll let you know who we're using. And just by way of just letting, well, Stefan's our consultant, we use it, we have an online. And yes, I think there's a prime time for me to say to my members and those that are listening. Now, we've created an application called the DPCP, that's a Data Protection Compliance Program. We have had it up and running, and then we've had to stop it with the last 3 months of submissions from the regulator because there were certain regulatory forms that we wanted to put into that system. So we are working on a very practical system of helping anyone from a small one-man operation to a blue chip on going through a compliance process with a check, because we found that there's a lot of uncertainty, and if we can put an application that takes you 0.1, 2, 3, 4, 5, and you feel more comfortable in knowing that we rated at 80%, and the system will then give you guidelines on where else you should be looking at fixing or bolstering. But that is going to be released very soon. We had it up and running, but again, when the regulator brought out new regulations, we had to tweak it, and that's what we're doing currently. So that's on its way. Let's move on. There are questions I'll try to get to. We have to finish at 1:30, but let's just finish our question sheet of the FAQs, the frequently asked. Numbers, I think it's number 7 now we're on. We do have a database that we do dupe against the do not contact list and have an unsubscribe option on all emails. What other measures can a small training company take? Here's a quick practical one. Quick, but we say it's quick. In terms of POPIA, when I discuss POPIA with another company, Michelson's, who are also very good consultants of ours, the into play always, and very much in line with the principle-based regime which POPIA is. You got to do what is practicable. And I always give the examples where, if you were a small you were a doctor and you kept your files in a locked cabinet, would the regulator come and tell you need to digitize stuff and have a firewall and a server and go to an Azure cloud and pay tens of thousands of dollars to secure that? Or what is practical? Is a steel case locked with secure burglar guards around your and a 24-hour guard sufficient? I think the word practical comes in and practicable comes into play when you're looking at costs versus doing business. It just would not be practical for somebody to go and start spending millions on servers and cloud services where it's not practical. But if you're running a bank, well, that again is a different story. You definitely will have to pull out all the stops. So that's just a practical approach to what more should we do? Anything to add there, Stefan, on number 7?
Yeah, I think just the principle, I think the takeaway for me is that, the important thing is that purely deduping or using the DNC doesn't make you compliant. I think number one. And, ultimately, what POPIA's effectively done is it's changed the sort of, we make use of various different terminology, opt-in, unsubscribe, opt-out, unsubscribe, or subscribe, these terminologies, etc. But I think there's a couple of practical things that you have to, it's good practice to dedupe your database, number one, because we can register our contacts with the DNC and you can see who's sort of, there and who doesn't want to be contacted. It's also good practice and probably arguably a requirement to maintain your own internal do not contact list so that you don't contact and engage consumers and data subjects who have specifically asked you not to. So I think that is what one needs to do is I think, use the DNC, but maintain your own internal DNC, if you will. And also, I think ultimately, I don't think unsubscribe as an option is enough now anymore because the POPIA Act actually has changed the sort of dynamic, which was previously regulated by the Consumer Protection Act. So you can direct market to somebody once, but you've got to do certain things in order to continue to do so. You can't keep shooting the shotgun at them and then, if they don't unsubscribe, continue to do it. That is not going to fly anymore in my view. So I think reasonably speaking, continue with the DNC. It's good practice, maintain your own, and then confirm and establish whether you need to get specific consent, if you're doing this on a direct marketing basis.
Thanks. I mean, as we were talking, there's quite a relevant pop-up from Khalalelo Sechone. I hope I'm saying that right. It says here, the requirement for direct marketing is that the data subject be contacted once in order to obtain consent. Does this apply if the data subject is to be contacted months or years apart? And here is an example. If we contact the subject now for insurance, they indicate they're fine or they're not interested. 3 months later, we see that the data subject is no longer insured. Can we contact them again?
Are the two of you throwing that one at me? Okay.
Yeah, go.
All right. Okay, so ultimately, I think just to sort of support again what Alison said, I think we can't forget about the principles here. So at the end of the day, we have to also just apply our minds and be logical about this. I've been confronted with this question, where, okay, so now a data subject on our database was a consumer that opted into an SMS that we sent them in 2013, as an example, okay? So now you can choose to interpret that as, broadly as what you want to, but and sort of create the position that is your customer and that you can contact them again for a different financial product or whatever the case might be, effectively 9 years down the line. I don't think you can do that. I don't think that is the way to go. I don't think that is being true to the spirit and the purport of what the legislation is trying to achieve. So I think you must ultimately make that call and see, it also depends on how closely related are the sort of purposes for why you are processing their personal information. We've got to read that together with sort of a practical kind of, don't be opportunistic is what I'm saying, I think. Be very careful about how you approach that because the intention of the regulator is not to put us as lead generators out of business. It's to regulate the way in which we process the personal information of data subjects and to make sure that we protect and safeguard the privacy of data subjects and individuals at the end of the day. So yes, that might imply and mean that we are now going to have to do business a little bit differently, But my view ultimately is we can sort of sit and cry about it, or we can embrace it and, adapt and be agile to change.
Thanks, Stefan. And there's a quick one here. It says, does the once-off message that you request for consent, does it have to have one particular offering, or can you request for a combined offering if somebody wants, in practical terms, you're saying you're asking for consent to talk to someone about lawnmowers and magazines and carpets. Can I contact you? I'm just putting it out there.
No, I think that's what it boils down to, David. I think we must, ultimately you can process personal information for a specific, explicitly defined, lawful purpose, and, for a purpose that's legitimately connected to your purpose as a business. Okay. So I think everything that you do in interpreting those things, it's like somebody who argues that potato farming is exactly the same as game farming. I don't think you can sort of argue that. It's an instance that I've had.
I thought you were going to say potato farming and vodka sales.
No, it's just a practical scenario that I've had recently. I think ultimately we must go back and sort of be realistic about our interpretations, and that's my view.
Okay, so yes, a multiple sales pitch can be done as long as the customer says, no, I'm happy to get all 3 or 4, or no. So it's opt-in or it's opt-out. But you were specific in saying what it is you're going to talk about or market. Cool. So I think we're on the end here. It says here, I think number 8 and 9 are very similar. So I'm going to jump to 9, and because we've got, I think, about 3 minutes. We do have a privacy policy. How will we know that it's right and it's in line with POPIA?
Send to Stefan and ask him to check it.
that is a whole consultation. I know that. That is a consultation going right there. But I think Stefan was very also succinct when he had sent us. You did a view for us in terms of a stepped process, Stefan. I think you had given us 9 steps. Let me just read them, and I think because for time and also some of our members want to get tell me quickly point for point. Look,
sorry, David, before you start, I just want to say I think perhaps it would be a good idea to share with the attendees this list, and also everybody must just understand and appreciate that there's not a blanket approach. This is the product of our years of experience in this particular field and how we've evolved our approach. So it's not that we say step 1 needs to happen before step 2 necessarily. This is the overall approach we believe is the right way to go. So sorry, go for it.
Yeah, always the legal advisor. You have to do the disclaimer there, Stefan.
We have to.
So basically, and I've got a slideshow that I would share with you. It's on here practically as a slideshow. So if you want to, info@dmasa.org, and we'll send it through to you. So step 1 here was basically appoint your registration of the appointment of a registration of the information officer or deputy. Step 1. Step 2, personal information impact assessment. So do your assessment as step 2. Step 3, training and awareness. And that is everybody needs to be made aware of, why, the what, the how of the data in your organization. So there's buy-in. And they're very aware of the infringements and the security issues around data. Step 5, POPIA manual. POPIA is still with us, and it's a very important component that you have to apply, because POPIA then talks about the security of the consumer and still maintaining still giving the power to the consumer so that they can ask about their data and what do you have on them, and you need to be truthful and honest with the owner, who is the actual owner of the data. And even in your HR departments, you need to send a circular saying hi, we have so much of your data. We will be moving your data to our head office, and for this purpose, you are being informed, blah, blah, blah. So step 6, terms and conditions, always terms and conditions around how data will be managed, held, moved to certain parties, restrictions and so forth around the data. So you need those terms and conditions. Step 7, privacy notices and consent forms. Those will be, again, like you were saying, Alison, keep records. If I'm allowed to send this data to someone, he needs to sign for it and understand that they can be only processed so far and handle so much, and then secured in this way. And then step 8 was data sharing protocols. Again, how do we move data between departments and for what reason? And step 9, technical information security policy framework and protocols. Again, how you're going to protect the data, and those protocols must be existing. So there are 9 steps, very practical, but each of them in their own right, like Stefan says, we need to go deeper into it. But that's just the framework. I think.
Sorry, David, can I just jump in here about a company being compliant? Slightly different question.
Yes.
So, for instance, what we've done to help credit bureaus, we first looked at what kind of data are we managing? Where does it come from? So we've identified all the incoming data, all the data we're holding, and then all the outflow of data. So do that in your organization. Just draw a picture. Here's where it comes in from. This is what happens within, and that's where it goes to. And then look at how POPIA affects each one of those bits of data. You can't always identify whether you're the responsible party or the operator, but in some cases you can. Then identify yourself immediately, because in POPIA there are different obligations for an operator to a responsible party. So that's probably the very first thing you should do in your organization. Draw where your data is coming from and going to. Then look at the law, and you will need, if you're not easily able to read POPIA, you will need somebody to help you. And then there are a few key things you need to look at. You need a retention policy. You need to work out what is going to happen if there's a breach in your organization or with your data. And this, again, you need to document. Document your retention policy. POPIA says you can only keep it for the purpose, or for as long as the purpose for which it was collected is relevant. Those are bad words, but effectively you mustn't keep it longer than it should be kept for the use for which it was intended. So then have a retention policy that says you will delete after so many years or after such and such a circumstance. That gives you your retention policy. So none of this is rocket science, but you do have to think. Then Section 23 of POPIA says if a data subject comes to your organization and says, what information have you got on me? You have to share it. That's a really difficult one. You need to work out how you're going to do that. How are you going to share all the information, and how are you going to tell someone what you hold on them? So that's another key thing you need to know. Then you need to look at agreements. If you're the responsible party, you are obliged to enter into written agreements with an operator. So you need to see where you're the responsible party, that you can absolutely identify it, and where you're sending data to an operator, and you need an agreement in place. And then you need to look at your websites to see if you need to put up website notifications. And again, you're going to need an expert to help draft it. We have 6-7 lawyers within the Credit Bureau Association. We got an experts. So depending obviously on the size of your business, I think David's doing a lot to help all of its members so that it kind of lowers the cost. So, you know, use your association to help you, but this is something you're going to have to do within your own organization.
Thanks, Alison. Yeah, that really just adds, you know, it gives so much information to the viewers and the listeners. Unfortunately, we have run out of time, and I'm going to have to close. There's a lot more, and I think we're going to do another slot similar to this going forward. I want to say thank you to the attendees, and thank you to Stefan and Alison for batting the questions. They're not easy, I know, and for the listeners, they're not as succinct as you'd like them. But come onto our website. We are developing some tools, and like I said, in the end, I'm going to let you know that together with the Credit Bureau and Association and the DMA, we're having a roundtable. So we'd like you guys to put forward your associations to also come to the roundtable to sit and listen. There's a stressful period we're going through, and we want to open up a conversation on how can we best assist the regulators and ourselves. And I think the practical ways we are looking at is saying, how do we aggregate, for instance, the Chief Information Officer's register? The DMA can take its 300 members and get the register done very quickly on an app, and it would be aligned with the regulator's form, and it can do likewise with pre-authorizations. And we'd like to hear ways in which we could combine forces and say, can we do it and take all of these to the regulator together, so that we combine forces and we don't, and we rather bring the regulator into those kind of conversations. I've already sent the email off to the regulator saying we're doing a round table, and I like to be open and honest. We don't want the regulator to think that, oh, we've got some ganging up on the fact that they are not taking in CIOs on their website. We're doing it in the interest of moving us forward and making sure that we keep South Africa as a lighthouse or a diamond in Africa for top legislative compliance. So that's what we're going to be doing at the roundtable. Put your names down. Let me know what your associations are as well. info@dmasa.org. So
and
thank
it does
you,
look
everyone.
like the Information Regulator site is up again.
Is it? Yeah, we can help them do that. I mean, we've got all the tech savvy. And I think, I have spoken with Pansy as well as a team, and Colin. They're really, like you say, they're people like us. They've got a huge task. And I think when we practically put our heads together, it's teamwork that'll get us all going in the same direction. So goodbye. Have a good evening, everyone.
Thanks,
and
David.
Thank you.
Thank you, David.
Thanks,
Thank you,
David.
Alison. Thank you,
Bye.
everybody.
Thanks,
Thank you.
everyone.
Thanks, everyone.
Bye-bye. Bye-bye.
Cheers, everybody.